Dear friends, good morning to all. This is your RAPETI Suryanarayana advocate from Visakhapatnam. In the earlier sessions, I gave many lectures with regard to various topics. All those lectures are important, useful, helpful to the practicing advocates, law students, and to students who are appearing for judicial competitive exams and other competitive exams. And those lectures are also helpful for legal awareness to the public. In this session, I would like to give lecture with a very wonderful topic. The name of the topic is caveat. What do you mean by caveat? What is the purpose for filing a caveat in court of law? Why we have to file a caveat in a court? Is there any use for filing a caveat in a court? Let us see in this session in a detailed manner. For example, you are having a property. Imagine A having a property and enjoying that property. That means A had a property and A is in peaceful possession and enjoyment of property. And B is there. B want to grab or occupy A's property in unlawful or illegal manner. Here the property belongs to A and A is in possession and enjoyment of the property. B is not having any title or any interest or right on that property, but that B have malified intention to grab or occupy unlawfully or illegally A's property. And this information, the way of malified intention of thinking by B came to the knowledge of A. That means A have a title deeds, right and interest on the property, and A is also in possession and enjoyment of the property. That B, without having any right, interest or title over that property, he want to grab A's property, and that A got a doubt that B wants to grab A's property, and A is also having a doubt that B may file a case against A in a court of law, and B may obtain a order in a court of law. Then the A is having a doubt on the B that B may file a case or suit over his property in a court of law. Then to aware or to abstract or to take caution or to beware of that case or to show his rights and title and interest over A's property. A, with previous precautions, may lodge a caveat in a court. Why? Because A have a doubt that B may file a case against A with regard to A's property. So, A, with previous precautions or care, want to protect his property without having to obtain any decree or order in favor of B, A have a right to file in a court a caveat. That means if A files a caveat in a court, then without notice on the A, that means caveator, who files a caveat in a court is nothing but known as caveator. Without notice on the caveator A, the court will not give any order or judgment in favor of B. Okay, I hope it is clear to all. The caveat is the nothing but beware. That means he is careful to protect his property and for not to have any order or not to obtain any order, decree by any other person on whom that person A have a doubt, then A may file a caveat against such person. Why? Because A is having a doubt that B may file a case and obtain an order without hearing on the side of A. So, to protect that and to protect A's property, A have a right to file a caveat in a court of law. Okay? In a detailed manner, I will give a lecture in this session. That means, according to section 148A of Criminal Procedure Code, is deals with caveat. That means right to lodge a caveat in a court of law. Right to lodge a caveat. Right to lodge a caveat is stated in section 148A of Civil Procedure Code. I hope it is clear to all. Let us go to the first point, where any person where any application is expected to be made or has been made, where any application is expected to be made or has been made, where in a suit or proceeding, instituted or about to be instituted in a court. Once again, I will repeat this point. When we have to file a caveat, let us see. Where an application is expected to be made or has been made in a suit or proceeding, instituted or about to be instituted in a court. That means somebody may file a application in a court, expecting that somebody will file a application in a court. Okay, where an application is expected to be made or has been made in a suit or proceeding, instituted or about to be instituted in a court. Okay, then that means one person is having a doubt that any application is expected to be made or has been made in any suit or proceeding, instituted or about to be instituted. That means the person is having that somebody may file an application in a suit or proceeding in a court. Then that person is having a doubt that somebody may file an application in a suit or proceeding in a court. Then what that person have to do? Then any person claiming a right, to appear, on the hearing of such application, in a court may lodge a caveat. I hope it is clear to all. That means this person is having a doubt that someone may file an application in a suit or proceeding in a court, or someone may file an application in suit or proceeding in a court. Then this person having a right for what? This person having a right to appear before the court on the hearing of such application. This person having a right, this person claiming a right to appear on the hearing of such application may lodge a caveat. That means person is having a doubt that another person may file an application in a court. Then this person may file a caveat in the court for to claim his right to appear on the hearing of such application. That means this person want to appear before the court on the hearing of such application. Why? Because he is having a doubt that someone may unlawfully or illegally grab his property or cause injury to his property. So, with previous or with precautions, he want to appear before the court on the hearing of such application, which may file by another person against this person's property If the person appears on the hearing of such application, then the court may pass order on merits. If this person is not appear before the court on the hearing of such application, then the court may pass order in favor of another person, due to which this person may suffer a lot. Without having any injury, to take previous precautions, this person is filing a caveat to appear before court on hearing the such application. If the person appears before the court on the hearing of such application, then the court may pass order on merits. Then there will be no injury caused to the genuine person. I hope it is clear to all. Once again I will repeat this point. This is very important. Where an application is expected to be made, okay, where an application is expected to be made or has been made in any suit or proceeding instituted or about to be instituted in a court. I hope it is clear to all. That means the application is expected to be made in a suit or proceeding instituted or about to be instituted in a court. Then any person claiming a right, to appear before the court, claiming a right for what? To appear before the court on the hearing of such application. Okay? Any person claiming a right to appear before the court on the hearing of such application may lodge a caveat. That means any person claiming a right to appear before the court on the hearing of such application may lodge a caveat. That means this person may lodge a caveat in a court. For what purpose? To claim a right to appear before the court on the hearing of such application. Which application? An application which is expected to be made or has been made in a suit or proceeding instituted or about to be instituted in a court. I hope it is clear to all. If any person is having a doubt that an application is expected to be made in a court, then this person may claim any right to appear before the court on the hearing of such application which is expected to be made in a court by what? By filing a caveat in a court. For what purpose we are filing a caveat in a court? To appear before the court on the hearing of application which is expected to be made in a court. I hope it is clear to all. Let us go to the next point. Where an application where a caveat has been lodged. Where a caveat has been lodged. Then what the caveat have to do? Where the caveat has been lodged, the person by whom the caveat has been lodged, is nothing but known as caveator. Where a caveat has been lodged, the person by whom caveat has been lodged shall serve a notice of caveat, shall serve a notice of caveat by registered post with acknowledgement due. Once again, I will repeat this point. Where a caveat has been lodged, okay, in a court, the person by whom the caveat has been lodged shall serve a notice of caveat, shall serve a notice of the caveat by registered post with acknowledgement due on the person by whom the application is expected to be made or has been made in a court of law. I hope it is clear to all. That means the caveator shall serve a notice of caveat on the person by whom the application is expected to be made in a court of law. That means if any person having a doubt, that such person may file a application in a court, and this person files a caveat in court, and the person who files a caveat in a court, that person is nothing but known as caveator. This caveator shall serve a notice of caveat on the another person. That means the person who files an application in a court of law. I hope it is clear to all. Once again, I will repeat this point. Where a caveat has been lodged, the person by whom a caveat has been lodged shall serve a notice of caveat by what? By registered post with acknowledgement due. To whom this caveator shall serve by registered post with acknowledgement due? On the person by whom an application is expected to be made or has been made in a court of law. I hope it is clear to all. Let us go to the next point. Okay. Where after caveat has been lodged in a court by the caveator, after caveat has been lodged by a caveator, that means the person who files a caveat is nothing but known as caveator. Where after caveat has been lodged in a court, then an application is filed in a suit or proceeding in a court. Okay. After a caveat has been lodged in a court, an application is filed in a court, then what the court will do? The court shall serve a notice of application to the caveator. I hope it is clear to all. Once again, I will repeat. Where after caveat has been lodged in a court, application is filed in a suit or proceeding in a court, then the court shall serve a notice of such application to the caveator. That means who files a caveat in the court. I hope it is clear to all. That means after caveat is filed, any application is filed in a court, then the court shall serve a notice of application to the caveator. Why? Because the caveator files a caveat in a court initially, before the caveat is filed by the caveator. Before filing of any application, the caveator files a caveat in the court. So before filing application, the caveator files caveat in the court. Then, after filing a caveat, if any application is filed in court, then court shall serve a notice of application to the caveator. Why? Because the caveator filed caveat before the application is filed in court, in the court. I hope it is clear to all. Why? Because initially the caveat is filed in the court by the caveator. After filing of caveat, an application is filed in the court. So the court shall serve a notice of application to the caveator. I hope it is clear to all. Let us go to the next point. Okay, where a notice of the caveat has been served on the applicant. That means, who is the applicant here? Who files an application in the court is nothing but known as applicant. Where a notice of the caveat has been served on the applicant. That means, who files application in the court. Then what this applicant have to do? After receiving the caveat, then this applicant shall furnish the copy of application which he filed in court along with all papers or documents or any papers or any documents which has been filed by him along with application for support of such application. I hope it is clear to all. Where a notice of the caveat has been served on the applicant who files an application in the court, then what is the duty of this applicant then? This applicant shall furnish the copy of application and also copies of any paper or documents which filed by the applicant in a court for support of his application. I hope it is clear to all. That means, where a notice of caveat has been served on the applicant, then the applicant shall furnish to the caveator copy of application and also all the other documents which are filed by the applicant in the court for support of the application. That means, the applicant shall furnish to the caveator copy of application and documents which are filed along with the application in the court for support of such application. That means, whatever the copies along with the application, okay, the copy of application and copies of documents which are filed in the court by the applicant, all those copies shall be given, furnished to the caveator. Why? Because this applicant filed those copies in a court to obtain order for hearing before the court on such application. This caveator should have knowledge with regard to the application what he made in a court of law. For such purpose, all the copies that is copy of application and all the copies which are filed along with the application in a court by the applicant, all those copies shall be given or furnished to the caveator. For what purpose? For defense or to defend his case. I hope it is clear to all. That means for the purpose of defense, for the purpose of hearing, to know what is present in the application which is filed by the applicant, all the copies of application and the documents which are filed along with the application shall be given to the caveator by the applicant. I hope it is clear to all. Next point, this is very important point. Where a caveat has been lodged, what is the time period of that caveat? The time period of caveat is 90 days. From when onwards? From the date on which it is lodged. Once again I will repeat. Where a caveat has been lodged, such caveat shall not remain in force. Such caveat shall not remain in force after expiry of 90 days from the date on which it was lodged. I hope it is clear to all. Where a caveat has been lodged, such caveat shall not remain in force after expiry of 90 days from the date of the order on which it was lodged. That means the time period of caveat is only 90 days. From when? From which, on which caveat was lodged in a court of law. Okay? Then, if the application is filed before the expiry of 90 days, then no problem. Then automatically the applicant shall serve a notice of application on the caveator. That means here, where a caveat has been lodged, such caveat shall not remain in force after expiry of 90 days, okay, from the date on which it was lodged, unless the application has been filed before expiry of such period or said period or 90 days. I hope it is clear to all. Where a caveat has been lodged, such caveat shall not remain in force after expiry of 90 days from the date on which it was lodged, unless an application has been made before expiry of 90 days. That means if no application has been made within a period of 90 days, then what is the use of caveat? The caveat will not remain in force. Why? Because the 90 days period is over. We have to file fresh caveat again. That means the caveat time period is 90 days. Within 90 days only, the caveat have a force. The caveat will have a force only up to 90 days. After completion of 90 days, the caveat will not have any force. If within 90 days any application is filed, then the applicant shall serve a notice on the caveator. If the applicant is filed an application after expiry of 90 days, then the applicant need not serve any copy of application to the caveator. Why? Because the caveat time period is over, that is 90 days time period is expired. I hope it is clear to all. That means, once again I will repeat this point. Where a caveat has been lodged, such caveat shall not remain in force after expiry of 90 days. The caveat shall not remain in force after expiry of 90 days from the date on which it was lodged. That means, from the date on which caveat was lodged in a court of law by the caveator, unless an application has been made before the expiry of 90 days. Okay, I hope it is clear to all. That means, unless the application has been made before the expiry of 90 days. That means, if 90 days time period is over, then there will be no value to the caveat. That means the caveat is expired. Why? Because 90 days is over from the date on which the caveat was lodged in a court. So, the applicant need not furnish any copy of application to the caveator. Why? Because the time period is over. If any application is filed before the expiry of 90 days, that is caveat period, then the court shall serve a notice of application on the caveator. Then the applicant shall furnish copy of application and also other copies of documents to the caveator. I hope it is clear to all. Once again I will repeat all those points in a brief manner. Keep your attention. First point, where an application is expected to be made or has been made in a suit or proceeding instituted or about to be instituted in a court. Where an application is expected to be made or has been made in a suit or proceeding instituted or about to be instituted in a court. Okay, that means we are expecting that somebody is filing an application in a court. Then any person claiming a right to appear before the court on the hearing of such application may lodge a caveat. That means we are expecting, that means some person is expecting that someone is filing an application in a court to obtain an order from the court. Then this person claiming a right, any person claiming a right to appear before the court on the hearing of such application may lodge a caveat. That means this person having a doubt that someone may file an application in a court to obtain an order from the court. Then this person may file a caveat for what purpose? To appear before the court on the hearing of such application. Okay. This person claiming a right by what? By filing a caveat in a court. For what he is filing a caveat in a court? To appear before the court on the hearing of application, which this person having a doubt that application is filing in a court and to obtain an order. I hope it is clear to all. That means the person claiming a right to appear before the court on the hearing of such application may lodge a caveat. That means this person may lodge a caveat in a court to appear before the court on the hearing of such application for not to get any order to the another person. Okay, I hope it is clear to all. That means the court will pass order on merits. It may be in this person or it may be in favor of another person. That means the court may pass on merits on the hearing of both the sides. Why? Because this person files a caveat in a court. On the hearing of both the sides, the court will pass a order on merits. It will be beneficial to both the parties. Okay, there will be no one-side hearing and the court will pass a order on one-side hearing. Why? Because the caveat is filed by this person. If the caveat is filed by one person, then this person claiming a right to appear before the court on the hearing of such application, then the court will hear on both sides and pass an order on merits. Then that will be beneficial to both the parties. I hope it is clear to all. Where a caveat has been lodged, then the person by whom the caveat has been lodged shall serve a notice of caveat by registered post with acknowledgement due on the person by whom such application has been made or is expected to be made in a court of law. I hope it is clear to all. That means the person who files a caveat is nothing but known as caveator. This caveator shall serve a notice of caveat to the another person by registered post with acknowledgement due. Okay, I hope it is clear to all. That means the caveator shall serve a notice, shall issue a notice or give a notice by registered post with acknowledgement due, a copy of caveat to the another person, which person is expected to be made or has been made to file by filing an application in a court of law. I hope it is clear to all. That means the person by whom a caveat has been filed in a court shall serve a notice of caveat by registered post with acknowledgement due on the person by whom an application is expected to be made or has been made in a court of law. That means the caveator shall serve a notice of caveat on the another person who is expected to make an application in a court of law. Let us go to the next point, where after caveat has been lodged by the caveat in a court of law, then an application is filed by the applicant in a court. Then the court shall serve a notice of application on the caveator. Why? Because the application is filed after filing of caveat in a court by the caveator. So the court shall serve a notice of application to the caveator. I hope it is clear to all. Next point, where a notice of caveat has been served on the applicant. That means applicant means the person who files an application in a court is nothing but known as applicant. Where a caveat has been served or received by the applicant, then the applicant shall serve or furnish the copy of application and also copies of documents which filed along with application for support of such application in a court of law. All those copies shall be given to the caveator by the applicant. Whatever the copies are filed in the court by the applicant, all those copies shall be given or furnished to the caveator. Why? Because the caveator filed a caveat in a court before filing an application by the applicant in the court. I hope it is clear to all. Next, what is the time period of caveat? only 90 days. Where a caveat has been lodged, such caveat shall not remain in force after expiry of 90 days. That means if the 90 days period is over, then the caveat will not remain in force. Such caveat shall not remain in force after expiry of 90 days. That means from which date onwards it should be calculated, the days will be calculated from the date on which it was lodged in a court of law. That means from the date on which the caveat was lodged in a court of law by the caveator. Okay, I hope it is clear to all. What is the time period of caveat? 90 days. From which date onwards? From the date on which the caveat was lodged in a court. That means the caveat will not remain in force after the lapse of 90 days from the date on which it was lodged in a court. Okay. Unless an application has been made before expiry of 90 days. That means if application is not filed in a court before 90 days, then such caveat will not remain in force. Why? Because the application is not filed within 90 days. If the application is filed within 90 days, then the caveat may remain in force and the court will order to issue notice of application on the caveator. That means the caveat shall not remain in force after expiry of 90 days unless an application has been made before expiry of 90 days. That means if before 90 days no application is filed, then no order will be passed to issue notice of application on the caveator. Why? Because the caveat is not in force. The caveat time period 90 days is over. If application is filed before the expiry of 90 days, then the caveat will remain in force and the court will order to issue notice of application to the caveator. So, if 90 days time period is over, then what we have to do? Then we have to file again a fresh caveat in a court of law, and same procedure will take place again. That means after 90 days the caveat will not remain in force. Then we have to file another fresh caveat in a court. Again same process. After filing a fresh caveat in a court, again we have to serve a notice of caveat on the another person, which person is expected to made or has been made an application in a court. By what? By registered post or with acknowledgement due. Same procedure, whatever the procedure have did in the initial previous caveat, same procedure have to follow for the fresh caveat for filing a caveat in a court of law. I hope it is clear to all. That means the time period of caveat is only 90 days. After 90 days, such caveat will not remain in force. Why? Because the caveat period is over. That means before 90 days, the application which filed by the applicant and after completion of 90 days, the applicant can file in a court an application without issuing any notice of application to the caveator. Why? Because the time period is over. So, this caveator again shall file fresh caveat in a court, and again to that fresh caveat the time period is 90 days. If again within that 90 days, that means within to the fresh caveat 90 days period is over, or not filed any application within for the fresh caveat time period, then again we have to file another fresh caveat in a court of law. Then again 90 days will be, time period will be present to that fresh caveat. That means to each and every caveat that time period will be present. If one caveat time period is over, then again we have to file another caveat. To that caveat, the 90 days time period will be present. If again the 90 days time period is over, then again we have to file another fresh caveat. Same process. Then the time period will be given 90 days. If within 90 days application is not filed by such person, that person, then again we have to file another caveat, and again there will be 90 days to that another caveat which you filed in a court. I hope it is clear to all. That means the only 90 days time period will be present to each and every caveat which filed in a court. Okay, that means if one caveat time period is over, we have to file next fresh caveat, then we will get the 90 days time period. If this time period is over and no application is filed within that caveat time period, then we have to file another caveat. Again, if no application is filed within that 90 days, again we have to file a fresh caveat. Then again 90 days will be given to that fresh caveat. Okay, these all process only when any person claiming a right to appear before the court on the hearing of an application which is expected to made or has been made in a court. Okay, the reason for filing a caveat is to appear before the court on the hearing of application which is expected to made or has been made by the applicant or any person. I hope it is clear to all. The reason for the purpose of filing caveat is nothing but to obtain a right to appear before the court on the hearing of application and to obtain order on merits on the hearing of the both sides on the application. Then there will be no injury or loss to both the parties. If caveat is not filed, then an application may be filed by any person and may obtain an order on hearing before the court, and the court will pass an order on hearing of one side. It may cause injury or loss to another person. So not to have that loss or injury to some person, that some person may have a right or to claim a right to appear before the court on the hearing of such application. If such person files a caveat in a court to appear before the court on the hearing of such application, then there will be no cause or injury to both the parties. Then the court will pass orders on hearing of both sides. So this is with regard to the caveat. This is very important topic. It is very helpful to the general public also. Okay, so I hope it is clear to all. So kindly share my videos to friends, relatives and others, and like my videos and subscribe my channel. Thank you. Thank you a lot.